Welcome to the New Books Network.
Hello and welcome to Madison's Notes. We are the official podcast of the James Madison Program in American Ideals and Institutions at Princeton University. I'm your host, Laura Laurent, and this week we are speaking with Associate Professor of Law at Yale Law School, Garrett West. His subjects include torts, remedies, federal courts, and administrative law, but today we're going to dive into the world of constitutional private law. Now, when most people think about constitutional law, they consider the large, headline questions of government structure. However, in our conversation, we're going to look at the possibility of applying constitutional law to the private realm and what that means. West is going to provide us with a refresher on some vocab for considering these ideas as we go into the legal theory, and we look at some of the unlikely history of constitutional law. This is a conversation that I particularly enjoyed because it doesn't necessarily provide us with answers, but it does a great job in informing us about the questions. So let's get into it. Professor West, welcome to Madison's Notes. It's exciting to have you here.
Thank you. I'm delighted to be here in Princeton.
Well, first, so you're here at Princeton to give a lecture this evening, so we get to be in person, which isn't always the case. Mm-hmm. Tell me a little bit about, first, how you got to the point where you are giving lectures at Ivy League institutions and have an associate professorship at Yale.
Well, that's a good question. I started at Yale as an associate professor at the law school this last fall. I'd gone to Yale Law School and graduated a couple years ago, and then clerked a couple times for circuit court judges, and then for Justice Alito on the Supreme Court, and practiced law for a couple years. And one of the benefits of teaching at a law school is that you don't have to go through a 7-year PhD program in order to get a job as a professor. At least you don't always have to. And so I've been teaching at Yale for a year now, and I love it. It's a great job. And as part of that, I suppose I was asked to come give a lecture here at Princeton University, which has had very many great constitutional law scholars in the past, like Edward Corwin, Professor Murphy, after whom the lecture I'm supposed to give tonight is named.
Yes. Well, so before we get into more of the meat around constitutional private law, which is what you're here to discuss this evening, how did you get interested in constitutional private law? Like, what were some of the defining moments or ideas or questions that came to you to signal that this was going to be a special interest of yours?
Mm-hmm. Well, in law school, I did a lot of constitutional law and also public law more generally. So I did a lot of courses on constitutional law with like Akhil Amar and separation of powers courses and federal courts issues. And so I was studying a lot of public law, but I also had an interest in private law and private law theory from the very beginning of law school. And so when I was thinking about what sort of work I was going to do and thinking about going on the academic job market, I thought that I could try to combine those two ways of thinking about the law and see if there was anything interesting to say. And so that got me looking at constitutional torts, what I call constitutional private law, and trying to apply some of the theoretical moves that scholars make in the private law world, torts and contracts and property, over in the world of constitutional law.
Okay, fantastic. So our listenership is somewhat academic, but mostly just people who are intellectually interested and engaged in the world. So I might ask you some vocab questions for us to just give us a baseline for understanding what we'll get into in a minute. As far as the world that you're speaking about, what you said, what you call constitutional private law, why do you make that distinction? Mm-hmm. And what's the background environment that allows you to make that distinction specifically?
Mm-hmm. Well, I think the background is that when people think, and I'm thinking specifically about your listeners here too, when people think about constitutional law, they think about the really big cases that make the front of the newspaper. They think about guns. They think about abortion. They think about the Affordable Care Act and judicial review of big legislation. But it turns out that a lot of constitutional law and a lot of cases about constitutional law are these things that are conventionally called constitutional torts. And so a constitutional tort is when you sue an official, usually a state official like a police officer or a prison guard or maybe somebody who works at the DMV for violating your constitutional rights, and you sue them and you ask for money damages. So these aren't the kind of cases that often make it to the front page of the New York Times or the Wall Street Journal, but they're very important for the particular plaintiffs, meaning somebody who's bringing a legal claim or filing a lawsuit. And also they make up a very large portion of the docket of the federal courts. I mean, 5 to 10% of the federal court's docket are these constitutional tort claims under a statute called Section 1983 and under well, I'll stop there. Yeah.
Oh, fantastic. Well, and so for me, as someone who isn't a legal theorist, it sounds as though the constitutional torts are managing, I almost want to say policing the federal government, but it's almost the integrity of the federal government to enact the legal stances that it's taken and that it's agreed to. And it's a way of maintaining integrity in that regard.
Mm-hmm. I mean, yes, and there are lots of different ways that you can think about what constitutional torts are doing. So one way in which you can think about constitutional torts is as a mechanism to try to make sure the government is behaving itself. So one theory of tort law and also of constitutional tort law is that what's happening with these lawsuits against officers is if you make them pay money damages, if you make them pay out cash if they do something wrong, if a police officer beats somebody up when he shouldn't, then maybe they're less likely to do it in the future. Mm-hmm. So that's one theory, is kind of a deterrence theory. We're trying to make sure that the government behaves itself. Another thing you can think of them as doing is a little different, but it's about correcting wrongs. Corrective justice is a term that's sort of associated with Aristotle. It's a very old term, and it's what some people think is going on in tort law. And that's a version of that theory is what could be going on in constitutional torts, because you might think that if officers violate somebody's constitutional rights, there has to be some kind of recompense. There has to be some kind of restoration. There has to be some kind of correction to restore the rights of the party whose interests have been violated.
Mm-hmm. Mm-hmm. No, that checks out. So the next thing that I want to get down clear is the difference between public law and private law. How do you make those distinctions? What's maybe the mainstream legal vocabulary of understanding those two things?
Mm-hmm. Well, the distinction is quite old, and today many people question it. They think it doesn't make a lot of sense. But let me lay out the distinction, and then I'll say why some people are critical of the distinction. So the distinction between private and public law is very old. It goes back to Justinian's Digest. And public law is usually said to to constrain the relations, how the government operates, and the relationship between the government and the citizens. So when you think about separation of powers, or you think about the Appropriations Clause, or you think about how Congress enacts statutes, or you think about the Bill of Rights and the Fourth Amendment and the Eighth Amendment, you can think of those normally as a form of public law because they're either about how does the government go about doing its business, or what kinds of constraints are on the government. Private law is usually said to be about the rights and duties of private persons to one another. So it includes things like tort law, contract law, property law. And so, tort is probably the most foreign of those categories, but you can think of tort law as anything where the law provides a remedy, usually in a form of damages, for wrongs committed by private persons against each other. And as some examples, medical malpractice claims can be torts. If you're texting and driving and you hit somebody, that can be a tort. If you punch someone in the face without good reason, that could be a tort. All of those are torts, and they're wrongs, and they're not crimes necessarily. They're civil wrongs, meaning that if you commit the civil wrong, you might be sued in court by the person you've wronged, and you might be forced to pay out damages for it. So that's tort law. Contracts, you get it. You sign the contract with, your employer or a business, and if they breach it or you breach it, you might have a dispute with them about that. Property law, you can't go on your neighbor's property, your neighbor can't go on your property, and so on. Just a question that from the outside. Could property or contract law be considered a tort law since there's technically still a wrongdoing happening? So is it an overarching classification that covers all these different sections, or does it get to be its own distinction? Yeah, in one sense. So I teach torts to first-year students in law school. So I'm a tort maximalist, and I want to say that everything is actually tort law eventually. Okay, yes, there's a way in which tort law and contract law are, in fact, the same branch. because they're both about the obligations that people have to one another. And so tort law is the kinds of obligations you get just as a matter of law to strangers. You don't enter into a contract with other drivers on the road, at least not a formal written contract, but you still have obligations to drive safely. And if you don't drive safely, then you might have to pay them money damages for harming them. Contract is just a special case on this view of a kind of obligation that you've gotten by agreement. So one thing that's funny about tort law is if you read definitions in treatises or case books, is they'll say a tort is anything for which the law provides a remedy except for contracts. Because we tend to sort of separate out contracts because there are special rules about the making of contracts and when they're enforceable and when they're not enforceable and what it means to perform a contract and when there's been a breach. But yeah, you can think of them as being related to one another in that respect. Also, property has what are called the property torts. And in fact, I teach property torts in tort law. And so trespass is walking on your neighbor's property. Nuisance is interfering with your neighbor's use and enjoyment of the property. So if you're playing loud music or recording a podcast at 3 a.m, you might be a nuisance to your neighbor, and they might be able to sue you to stop the nuisance or for damages. So you can say that all of those are a branch of tort law, sort of. But usually in law, we sort of separate them out and teach them differently.
Mm-hmm. So as you were describing your own teaching style, you said, I want to eventually get to the point where that tort law is everything. Maybe what's the other side of that? Why would somebody want to say that tort law isn't everything? Why is that distinction particularly important for what you're teaching and the way that you're presenting legal theory?
Well, one thing is that contracts and property have a lot of other rules in them that aren't about those breaches of obligations to people and what happens when you breach obligations. So a lot of contract is not about what happens at the back end when there's a breach and then you sue somebody for damages. A lot of contracts is about how do you make a contract? What kinds of contracts are enforceable? What kinds of terms can you put into a contract? And so on and so forth. So there's a lot of contract law that's very different because it's about forming and creating agreements and when those obligations come into being. Yeah. The same thing is true of property law, which is what kinds of legal interests are there and how do you transfer them? How do you transfer your property? How do you transfer different parts of your property rights to other people? And so that's another thing that is really not at all like tort law. And so that's one reason to treat it differently. The other reason is just that there might be very different reasons to have something like tort law and have something like contract law. And so I don't want to go on a long tangent to your audience about different theories of why we have torts and what they're supposed to be doing. But the reasons for having torts might be very different than the reasons for having contract law, precisely because contract is based on agreements between persons, what they've agreed to in theory. And torts are about obligations that people have usually irrespective of what kinds of agreements they've entered into before that.
Mm-hmm, mm-hmm. Now, I can see the complexity of specifically the contract law having so much more upfront to even understand if enforcing the contract is legal or proper or whatever before you can enter into any kind of tort process.
Right. Well, you have to have, let me put it this way. If you are going to allege a tort, the classic tort is negligence, and you have to allege there's been a duty, a breach, that the breach caused an injury to the plaintiff that's bringing the claim. So the duty there is thought about a lot in tort law. In contract law, defining the duty is really important, and the duty is defined by the agreement of the parties. And so there's a lot of work going into how to agree to something, when an agreement is a contract, because we could agree to things and it would not become an enforceable contract. So there are lots of rules about when things become enforceable. So yes, I'm agreeing with you.
Yeah.
There's a lot on the front end in contracts that's quite different from what's going on in tort law.
Yeah. No, that's really fun to get a little bit, not a simplification, but a better overview understanding of how legal theory and legal processes are thought about. I think a lot of people get the initial government education in their primary education or high school, or maybe even a few government classes in college. But after that, law might not be something that we all think about. So understanding some of the processes is helpful for us navigating our own life
when interacting with the public square. So as you were describing this, I was realizing that when I think of constitutional law, it's usually in the framework of how the government is structured. It's more about, like you said, those big cases that are going to affect amendments or, large structural pieces of the government. But as you described tort law, and specifically you go into you have constitutional private law, I would love to get a deeper understanding of maybe the empty space that you saw in the conversations of legal theory in regards to applying constitutional legal theory to these private and tort-based applications.
Mm-hmm. So I just thought that there were lots of analytical tools that had been developed to try to think about and talk about private law that helped to explain at least this pocket of constitutional law. And I also thought that there was that when people think about constitutional law, because they tend to think of it as those big separation of powers cases, there was a tendency to lump these constitutional private law claims, the constitutional tort claims, into the big separation of powers disputes. So the way you put it earlier was that this was about the integrity of the government or making sure the government behaves itself. And I think that might be true, but another way to think about what's going on in constitutional torts is it's not really about making sure the government behaves itself. That's normal constitutional law. It's really about the obligations that the officials themselves personally have to other persons. And if you think about constitutional private law that way, well, it frames some of the doctrines and some of the rules in a slightly different light, and it makes it a little bit less about those big structural constraints on the government as a whole and more about the question of what do officials owe individuals and what do people owe one another, rather than a big abstract question about what does the government owe us generally.
Mm-hmm, mm-hmm. Okay, I've got one question I'm excited to ask going down that. But before I want to ask a clarifying question. You said you thought that there'd been a lot of really good analytical tools for understanding private law. What were some of those analytical tools? What's an example of that?
A good example is just that there's a lot of people who are interested in private law are very philosophically minded in the respect that they pay quite a lot of attention to the structure of legal rules and what the difference is between this kind of legal rule and that kind of legal rule. So I was just walking through different classifications of tort law and contract law and so on. And private law people, or at least one set of private law people, are very interested in trying to articulate are the differences between these different kinds of legal rules and what's their specific structure and function. And so paying attention to the way the doctrine is operating at with very close attention to how judges think about problems of law. So I don't know about – I'm regretting a little bit calling it an analytical tool. I think it's just more an approach to the way of thinking about what's going on in the law and taking seriously that the concepts at work in the law are doing work on their own.
Is it correct to see what you're saying as these, not analytical tool, maybe just this approach, strategy, maybe of understanding it, is how you were able to discern when it comes to like tort law is more about the individuals representing the government to private citizens versus, quote, the government with a capital G,
right, versus,
in relationship to the individual.
Right. Well, let me give you a specific example of where I think this is helpful. When you bring a constitutional tort claim against an officer, you bring it in what's called the officer's personal capacity rather than the officer's official capacity. Mm-hmm. And if this sounds boring, don't worry. It bores my students too. But it's going somewhere, I promise you. And when you bring it in their personal capacity, what that means is that you sue the police officer or the prison guard, and if you win, the official is the one that has to pay the money damages.
Not like the police department.
Not the department. Well, you can sometimes sue departments, but usually you will sue the official, him or herself, and that person will have to pay. Now, it's also true that sometimes the department or the government will end up paying for the officer, but formally speaking, at the end of the day, if you want to go collect your judgment, if you want to get the sheriff involved and get paid, you're supposed to go and get it from the official, him or herself. And so a lot of people who do constitutional law think this is really weird. They treat it as kind of an unusual workaround to a doctrine called sovereign immunity, which is that you're not allowed to sue the government for money damages. And so a lot of people looked at this personal capacity suit and official suits where you sue officials and you ask them for money as a workaround of sovereign immunity and as a way to get money from the government when you're not able to sue the government directly. And when you think about these constitutional tort or constitutional private law claims like that as workarounds to sovereign immunity, well, then you start to think this is just kind of an imperfect and silly way to do it. Why don't we just allow suits against the government directly? So I think about it a little bit differently because I'm working from the doctrine itself and then trying to draw conclusions about what it could be doing from the structure of the doctrine. So I see the personal capacity function as a commitment to a different view of constitutional private law. Like I said, it's not about the government. It's not about getting money from the government. It's about getting money from the official. And if you think that the official's done something wrong and the official's the one who's supposed to make good the wrong done, it makes perfect sense that it wouldn't be treated as a suit against the government, and it makes sense that you might be able to be forced to bring the claim against the official directly in the official's personal capacity rather than bringing the claim against the government and getting money from the Treasury.
Mm-hmm. This is really interesting. In the public square, you said, oh, this might sound boring. I'm like, this isn't boring. I feel like this is very applicable to understanding, I feel like I'm consistently hearing news stories about lawsuits against federal institutions. So with this perspective of looking more at the question of what do we owe to each other, not regardless of role, but in relationship to the roles that federal individuals are representing, how do we begin from that stance? How do you begin to answer that question? Maybe we keep using this example of a police officer. Say a police officer has a contract with their department and they fail to perform their duties. And from this perspective, how would you start to think about this problem differently than maybe the more mainstream or track line that you described before?
Mm-hmm. Well, let me give you a couple different ways that you could think about what. We'll use police officers because it's the easiest to kind of wrap everybody's heads around. You can imagine we hear stories about it all the time, and so it's a useful example of what we're talking about here. There are a couple different historical models for thinking about what police officers or sheriffs or executive branch officials owe to individual persons. So constitutional torts are a relatively new approach and a new way of thinking about it. They emerge basically in the 20th century. And that model is the things that officials owe to the individuals have to be somehow tethered to the specific language and text of the Constitution. So there's the Fourth Amendment, and it says you're not supposed to engage in unreasonable searches and seizures. And so that is kind of a textual hook for the kinds of obligations that police officers might have. The historical way to think about the obligations that police officers had would be to treat them exactly the same as private citizens. And so common law, so you in the 19th century and early in the 20th century, if you thought the sheriff took your property and wasn't allowed to do it, or if you got beat up by a sheriff, you could sue him for trespass or battery under the ordinary normal tort law. And sometimes they had special defenses because they were sheriffs or because they were officers. But the way we would think about the obligations that they had is you would think about them as having regular private law, tort law obligations to everybody else. And so you can think about these two different models as approaching the same problem from two different directions. The old way was to treat the officers as ordinary citizens and say they have all the regular obligations of ordinary citizens. And sometimes we would treat them a little bit differently under the law because of their position as an officer. But the baseline was going to be they have the same obligations that any other officer has to that any other person has to everybody else. Today, we think that the Constitution is doing something special and different, and so we're starting from the initial premise that the officers have special responsibilities and obligations because of the text of the Constitution.
Okay, that's computing. As far as Okay, the second one, they have special responsibilities based off of the Constitution. It seems as though what we owe to each other on a baseline is like the higher bar. Mm-hmm. So what is the higher bar that judging them based off of special privileges based off of the Constitution would actually give them?
It's really interesting for you to frame this question like this, because when I present these options to law students, they have the opposite reaction. So I think law students have the reaction that, of course, the Constitution is special and different and more important in some respect than whatever obligations you have to other people as a matter of ordinary tort law or private law. They think, oh, tort law is boring and not that important, and the Constitution is special and unique and different. So it's interesting to me that you have the other intuition, and the more I've thought about it, the more I've kind of begun to share your intuition about this. And here's the reason. If you think that the obligations that officers have to citizens have to derive from the Constitution, then you have to fit them under very precise and specific textual hooks. And so in order to show that the officer has an obligation in some respect, you have to point to, hey, look, have you heard of the First Amendment? Or have you heard of the Fourth Amendment? Or have you heard of the Eighth Amendment? And if you can't point to a specific language in the Constitution, a specific textual provision, then you're going to be out of luck. And you won't be able to show that the officer had some kind of obligation. And if you think the Constitution is special and different, then that's fine, because you would think that the provisions that have been selected as the kinds of rules that officers have to citizens in the Constitution, well, those are special and different. So, of course, you have to identify one if you want to get out a claim. But if you think that what's happening in constitutional private law is really just a question of interpersonal morality, interpersonal justice, it's about what Aristotle called corrective justice, you might think that the Constitution's text isn't going to perfectly map on with what you would expect officers to do.
That's so interesting. I'm curious about okay, so you've started to grow towards this intuition, which I'll share again just to clarify even for myself, which is that if we say officers are they get some sort of special provision, or they are somehow imbibed with a higher standard based off of the Constitution that they're representing. To me, that sounds like we're then making the question of what do we owe each other underneath the Constitution. Like the Constitution is the big defining character of value in our society, and we base sort of all of our interactions off of that text. Whereas, what I'm intuiting, but might be wrong, who knows, this is a new subject for me, is that it's almost switched where what we owe each other is much bigger than what we can write down. And officers might be, they're required to follow the Constitution insofar as it's their job, but just because the Constitution doesn't specifically mark a particular action, that doesn't necessarily mean that they can't breach some other issue, value. I don't know what the word is for that.
Right. So maybe this might help, is that in the United Kingdom, there's a special tort called misfeasance in office, which is just abusing your office. So that might be what we think is distinctive about officials and their responsibilities is, are they abusing their power? Are they discriminating against certain persons rather than others? And that might be what you care about. And if you can't find it in the text of the Constitution, that would be a problem. Now, let me just add, one other question I get when I talk about this a lot is, well, if this is constitutional private law, maybe it would be better, maybe it would be a better world if you just had a kind of general common law for officers, but you can't just make up constitutional rights, and so you have to be limited to the specific textual clauses of the Constitution. And that's a kind of originalist argument, which is a very popular way of interpreting the Constitution right now, and I consider myself an originalist too. But the problem with the objection in this context is that constitutional torts are non-originalist. They did not exist for most of the nation's history. They did not exist until late in the 20th century. And so the idea that what's happening with constitutional private law or constitutional torts could be or is originalist is really challenging. And so I don't know that you can rely on the specific textual provisions to articulate the kinds of things that should be constitutional torts or constitutional private law.
Yeah, and it seems to me, even if you don't consider yourself an originalist, just the process of adding anything to the Constitution is so heavy that it seems cumbersome to enforce it in that way anyway. So is part of thinking about it in this way beneficial to being able to be more responsive to interactions between federal representatives of the government and individuals?
Yes, yes, maybe, possibly. One complication with that problem is that there is a statute that is implementing and allowing these claims to be brought. It's called Section 1983, and that's the statute that lets you sue a state official or a local official if they violate your constitutional rights.
As a state official.
As a state official, right. It doesn't apply to federal officials for complicated reasons that we don't have to get into right now. But Section 1983 applies to state and local officials. And so, Congress probably could enact a statute that tweaked the way the courts are developing and implementing constitutional private law or constitutional torts going forward. But there would be some constitutional constraints on what Congress would be able to do.
Let me preface this question by saying I've learned in speaking with academics and legal theorists like yourself, there's often like a specific argument that is being presented that has much larger ramifications on other parts of the practice, let's say, or of the sort of topical space.
Mm-hmm.
With your presentation of torts and constitutional private law, what are some of the other implications that one might not expect given the details that we've been going through in the last little bit?
Well, I think that this is still specific to constitutional torts and constitutional private law in Section 1983, but I think that my way of thinking about it as being about interpersonal justice or corrective justice actually provides a sounder foundation and justification for it and reason for judges to keep developing and implementing this area of law. And the reason that's true is this goes back to one of the first things that you said, which was it sounds like this is about making sure the government's accountable and generally within bounds. And that might be true, but if you think that what constitutional torts are doing is exclusively about making the government behave itself, then it's a really complicated empirical question about whether it's the right way to do it. And so that actually opens up a serious set of potential critiques to constitutional private law on the ground that it doesn't work, right? And so you might wonder whether officers respond to financial incentives appropriately. You might wonder whether they are afraid to do their job if they're required to pay money damages. You might wonder whether there are other bureaucratic tools that would make it easier, that would make the officers perform better. And so if you're justifying constitutional private law exclusively through the kind of deterrence approach or thinking about it as a way to constrain the government, then you have to answer a lot of complicated empirical questions before you would think that this is a good idea and it's worth it to do this. So my theory shores up the practice of doing constitutional torts a little bit better in a couple ways. One, it presents it as basically continuous with something that Americans have been doing for a really long time, which is suing each other for breaching their obligations. Like, Americans love tort law and they love litigation. And so this is putting that within that framework and within that history of corrective justice. Mm-hmm. The second thing is that my theory isn't quite as susceptible to the kind of empirical critique that I was just laying out. Because if the point is just, look, something bad happened and we have to make good on that, or this officer did something wrong and he owes compensation, then it's not about whether or not this is an effective or good way to make sure officers in the future do the right thing. It's about doing the right thing right here and right now. Mm. And so you still might not buy that. You might not think the officer did anything wrong, or you might think, we shouldn't We shouldn't pursue this expensive litigation mechanism to try to correct injustices. But it doesn't require you to go through all of the difficult empirical questions in the same way.
Mm-hmm. And it also, what I'm hearing too, is that it's emphasizing the response to the present moment and the present situation before it starts trying to control or influence the outcomes of the future.
Right.
It's a little bit, like you said, like corrective justice. And when you say corrective justice, because I want to get into that a little bit more to understand just a background of where that term comes from, but the corrective justice is the application or rectifying of power about the specific event, as opposed to trying to control or influence like a future.
Yes. Yeah. I mean, one way to cut it up would be to say this is about the past, this is about what happened and fixing what happened. And other ways of thinking about constitutional law are about the future and making sure that the government operates well in the future or now rather than based on what happened in the past.
Yeah. I mean, it sounds like both are important, though. So is your framework able to, I mean, it seems that it's focused on what happened in the past or what happened right now, let's fix it. And then does your framework account for the future? Is like, well, if we focus on what's happening now, we'll be better prepared to respond to whatever it is in the future.
Mm-hmm. I don't, but I don't so much, but there are the best kinds of legal regimes, the most durable legal regimes. Well, I'm speculating, but I'm going to speculate. The best and most durable legal regimes are going to be those where there are multiple overlapping justifications for them. So it would be great if constitutional private law both corrected injustices in the past and also had a good deterrent effect going forward so that the government behaved itself. Mm-hmm. If both of those things are true, that's a really good system because, wow, you get corrective justice and you get justice in the future. Yeah, exactly. It's a win-win. The problem is if you are a judge or if you are thinking about how the system should work, like an academic, those multiple overlapping justifications doesn't help you so much in figuring out what to do when the two justifications come apart. Mm. Because, you could imagine a world, and this is an empirical question. I don't really know the answer. Some might, but I don't. Where making officers pay money damages, it satisfies corrective justice, but it would chill their activity going forward. They're not going to do a very good job. And so you wouldn't. So if you care about corrective justice, you might say, well, we don't really care about deterrence in the future. We're going to make them pay the money damages now. But if you care about deterrence, you would say, we're not going to require them to pay out the money damages right now. Mm-hmm. And so where the justifications come apart, you have a question about how to proceed. And so I've been trying to focus on a non-instrumentalist, non-deterrence-based theory for why you might want to have these lawsuits, even if we don't know how it's going to work out.
Mm-hmm. Okay. This is good. Well, and as you were saying, if it's operating under a deterrence framework, that's making a lot of assumptions about what the deterrence is, right? Like if it is a gross misconduct and a police officer is sued for that gross misconduct and they have to pay out the nose for it, as a private citizen, I'd be like, oh, that's good. That's like a correct way of handling that. And if police officers don't want to get sued, maybe they shouldn't have gross misconduct, but I can see the need to keep the focus in the present moment, regardless. So you said earlier that, I can't remember exactly how you phrased it, but you said something about getting judges to implement more corrective justice. What does that look like? And how are you or is your work trying to be presented to judges in such a way that they can do that?
Mm-hmm. I mean, so we've been talking a lot about why would you have the regime? What does it look like? It's all very theoretical. But a lot of my other work is part of the work, too, is to look at what's going on in these cases and see where things are going wrong and where they're unusual and what's not making sense very much. So I can give you some examples of things that I think would make the system work a little bit better, especially if you cared about corrective justice. One of them is that some of these cases, constitutional torts, the way the courts determine whether or not you can make a claim, determine what the elements of the claim are, to take a beat for the listeners who haven't gone to law school, don't really know. If you sue a defendant and you want to win, you have to meet the elements of your claim. So you might have, I mentioned negligence earlier. You have to show there was a duty and a breach, causation and harm. Those are just the things that you have to show to get relief in the court. So one of the ways that courts have tried to implement constitutional torts is basically they've created claims that are kind of a mishmash of old common law claims and also modern constitutional tort claims. I don't think that really makes a lot of sense for some of the reasons that we talked about earlier, which is that, you either think about common law obligations or you can think about constitutional tort or constitutional private law obligations. It doesn't really make sense to combine them together and thinking about what kinds of claims can be brought. The other thing is calculating money damages. So there's lots of dispute about how to calculate what the damages number should be if an officer is found to be liable for violating the Constitution and a constitutional tort claim. And there again, there's ambiguity about whether the damages should be calculated based on the way you would calculate common law damages or tort law damages, or whether there should be special rules for constitutional law. There's also disagreement about what the damages should be designed to do. Should they be about compensating the person who's been wronged, or should they be about deterring officers in the future from doing the wrong thing? So that's another case where what you think this doctrinal regime is doing is going to alter the way you think about the doctrine and how you're going to develop the doctrine and how judges will actually resolve particular cases.
Mm-hmm. This is so fun to see how complex it is and get all the different layers. You outed yourself as more of an originalist, but also you mentioned that this tort law didn't really, it developed in the 20th century and that it's this newer way of looking at things. And so I see you trying to marry almost these two things that are they really opposed? What is originalists' issue with putting constitutional private law in with an originalist camp?
Mm-hmm. So I think that constitutional private law and Section 1983 is a challenge for originalists, or a particular problem for originalists, and here's why. Like I said, these claims in their current and modern form just didn't exist for most of the nation's history. They also didn't exist for decades and decades, almost a century after the statute Congress enacted that justifies these claims. So in 1871, Congress passes the statute that becomes our modern Section 1983, but it's not used to do anything like modern constitutional torts until the 60s, the 70s, and the 80s. So there's a really, really, really long delay. So if you need to justify constitutional torts in the specific activities and decisions of the founders or the people who ratified the 14th Amendment or the people who enacted the statute in 1871, you have a really serious problem because there's been a big practical shift in the way that we think about and talk about constitutional tort law today. That doesn't mean that there's nothing that you can do as an originalist or even as somebody who cares about the continuity with tradition. But here's where the sort of private law theory actually helps, because you have to come up with a theory for why what we're doing today is continuous with what happened in the past. And one theory is, well, they used to do the common law claims against officers. They used to permit those. And now we have constitutional tort claims that are kind of the same thing. It's just a different set of injuries. That theory is weakened if you think that constitutional torts are new and different and special. If you think that constitutional torts are really just kind of like private law as applied to officers, well, actually, it's a little more continuous with what was available in the past, because you would say, look, we used to do trespass claims against officers, common law claims against officers, but they would get special treatment sometime because of their position. And now we just directly sue them under Section 1983, and we call it constitutional private law, but it's really the same thing, and it's always been the same thing, which is about determining what kinds of obligations the officers have to private persons and making them pay money damages when they breach those obligations, when they act unreasonably, when they abuse their power, and so on and so forth.
What was it in the 60s and 70s that made the shift? Section 1983 was you said adopted in like the late 1800s, but it took a long time for it to actually start being implemented in the way that it, or exercised, I don't know what the right word is, in the way that it is today. So what was happening that made that shift?
There are lots of theories, and this is something that I do not have a good answer to, but I can give you some theories. One option is just that there was this case called Monroe v. Pape that interpreted Section 1983 very broadly to allow plaintiffs to bring claims against officers even when they were violating state law. And so that was uncertain before Monroe v. Pape. And that sort of allowed more claims to be brought when officers exceed state law authority, because then the officer couldn't get sued under Section 1983 and say, oh, but I was violating state law, so you have to sue me under. It's complicated, but the basic idea was there was one case in 1964 that seems like it might have generated a lot of litigation. Another theory is that there's this other thing going on in constitutional law separately from all of this, which is called the process of incorporation. And at first, people didn't think that the Bill of Rights, which originally only applied to the federal government, also constrained the activities of the states. But slowly over the course of the 20th century, well, beginning in the late 19th century, but through the 20th century, the federal courts began to incorporate the requirements of the Bill of Rights, like the Fourth Amendment, against the states. And so once that happened, you can have constitutional tort claims with Section 1983 because there are just more constitutional provisions that apply. A third possibility, and this is the most speculative, but a third possibility is just that there's a shift towards a more positivistic way of thinking about the law sometime in the second half of the 20th century, so that you had to identify specific constitutional provisions that were justifying your claim. So like in the old days in the 19th century, you could just come in and say, the common law provides me a right. And you could sue the officer under your common law claim. And there was a lot of flexibility and creativity that judges could use to try to articulate what kinds of obligations the officials had. But then somewhere in the 20th century, people stopped being the language's a brooding omnipresence in the sky was criticized in many legal circles. And so people moved to focus more on what specific texts and statutes said. And as that happened, you might think that whatever pressures there were to bring tort claims or claims against officers that would have been brought as just kind of common law claims are now getting now the plaintiffs are invoking specific textual language because you have to do that in our legal culture to articulate what your claim is.
Mm-hmm. Oh, this is, wow. I feel like something just clicked for me where I was like, oh, that makes sense. Like if people start growing in different directions of what they think common law is or its provisions or where it comes from, you're not going to be able to rely on it as much. So then you're like, well, if we have a society of a lot of different people with a lot of different opinions about what is sort of the baseline obligations we have to each other, that, leads to the more positivistic, like we need to have explicit numeric, really strong, clear lines how we can gauge people. But that opens up new problems where unless it is specifically written out, you can't enforce something that you might be like, wait, but that's wrong.
Right. And actually, I think it's worked out to be kind of a mixture of the two things, because even though there's been a shift to focus on the language of the constitutional provisions itself, it's not obvious to me that the text is doing that much work. It does seem like what's driving a lot of the analysis in a lot of these cases is background assumptions about what it means for an officer to behave him or herself with respect to the person. And so there are a lot of moves that really stretch the language of various constitutional provisions to provide for the possibility of constitutional private law claims against officers.
Okay, awesome. So this has been very interesting for me. I also don't have a background in this, and you are very well read and an expert in this. So is there anything that I missed about your argument, or any main claims, assumptions, or arrival locations that we missed in this conversation that is just really important for understanding as much of the breadth as possible?
I think you were a very generous and careful reader that picked up on the main threads of the argument. Now, one thing we didn't talk about was what this idea of constitutional private law should tell us about those other big cases. We started out contrasting like the Obamacare litigation, the Affordable Care Act litigation, and lawsuits against the Consumer Financial Protection Bureau. And we didn't talk about that, but I don't think we need to. I think the one thing that I would suggest is it's important to separate out it's important to think about different kinds of constitutional theories and constitutional claims differently. So we've been talking about constitutional private law, and I think those are different kinds of constitutional rights that have a different structure and a different kind of requirement of corrective justice. And I think it would be a mistake to translate all of those background ideas about corrective justice from Section 1983 and Bivens and damages actions against officers and bring it over into the big separation of powers cases.
Mm-hmm. Well, and what I feel I'm going to walk away with this conversation with is not necessarily concrete answers. I don't have concrete answers, but a deeper understanding of the questions to ask of like how, not just what is the structure, but how is the structure implemented and what's the difference between enforcing the structure versus holding individuals accountable, and just the very basic questions of how do we live in community with one another. But you've brought a really fantastic representation of the historical perspectives that this is all coming from, and being able to integrate the language with both your expertise and the expertise and examples that other positions might have. So thank you so much for coming on the show. This is so fun for me. My brain feels so big.
It was great to be here. Thank you so much for reading the paper. Thank you for talking about it. And thanks to everybody for listening.
Thank you for tuning in on today's episode of Madison's Notes. If you want more content focusing on academic thought beyond politics, philosophy, and society, make sure to follow us on your favorite listening platform and find us on social media under the James Madison Program. Madison's Notes is researched, hosted, produced, edited, and engineered by me, Laura Laurent. And if you have comments or ideas for future guests or episodes, feel free to reach out to me through the James Madison Program social media. Thank you for tuning in, and I'll see you next week on Madison's Notes.